evening, our esteemed viewers. You are welcome to a fresh edition of your federal program, Democracy and Rule of Law. A program where we delve deep into politics, trending issues that have to do with the Constitution and other areas of governance. In today's episode, we are going to look at two trending controversial issues. One of them is the issue of the retention or removal of immunity of the vice president and their deputies. The question will be, is it necessary to remove those immunity clauses or to retain them in our constitution? The other issue has to do with the issue of amending our constitution to make provision for a prime minister. Would that be in the interest of Nigerians and in tandem with our presidential model of government? We shall be looking at these two topics, and I'm sure that with our guests already seated, we'll have thought-provoking discussion on these topics. We're going to a short break, and when we come back, I'll introduce our guests who are already seated. My name is Obiorame. Stay tuned. We'll be right back. You are welcome back. If you are just joining us, we are on to your favorite program, Democracy and Rule of Law. And in our studio this evening, we have our guests already seated. We have, by my immediate right, Master Deji Olaleye, a seasoned legal practitioner based in Lagos and an academist. You are welcome.
Thank you very much. It's a pleasure to be here again.
And also with us is also a seasoned legal practitioner, Master Mike Omonam. As Mike, you are welcome.
Thank you very much. Good evening, ladies and gentlemen.
Yes. And without wasting much time, we want to go to the very nitty-gritty of the questions that need to be answered this evening. We want to look at the issue of the retention or otherwise of the immunity clause, apart from that of the president, that of the vice president, governors, and deputies to be removed. Will that be in the interest of proper administration in Nigeria or not? I will start by asking Mr. Deji, can you give us an insight into how this immunity clause come into being as part of our legislation?
Thank you much. I think the question of immunity for high state officials is something that we inherited from the received laws that we adopted from English laws. Of course, everybody knows that the Queen, that is the head of government in the UK, does no wrong. And the idea of trying to insulate public officers or high state officials from prosecution or from investigation or from criminal charges evolve as a way of protecting those who are in high government offices from necessary interference by members of the public during their tenure in office. And the idea is to protect those who are in government from multiplicity of litigation or claims or even either civil or criminal. And so it was received into our laws and was formulated as part of the Constitution to grant immunities to high state officials like the president, the vice president, the governors, and their deputies as a way of trying to protect them from unnecessary distractions in the course of carrying out their official responsibility. And I think it was that justified the inclusion of Section 308 of the Constitution of 1999.
Oh yes. We have made it clear that we heard it from our colonial masters who had a system that believed that the Queen can do no wrong.
Yes.
And because of that, they tried to grant immunity to all those that were in positions of authority. And in 1847, they amended their laws to remove thought from what the Queen was exempted from. And of course, they adopted the Petition of Rights Act, where before you can institute any action against the government or the Queen, you must get consent but eventually those things were done away with.
Okay.
Now, Mr. Michael Monam.
Consent of the Attorney General.
Yes. Now, Mr. Michael Monam, what is your view on the issue of immunity per se? Is it something that should be part of our constitution or not?
Thank you very much, my brother. This constitutional immunity in favor of the president, the vice president, and the deputy governor has been on the front burner for quite a long time. And each time I have an opportunity to speak on it, I kick against the existence of this immunity in our law books, the constitution as it were. Governance, from the way we see in Nigeria, maybe it would be okay in any other climate, but in Nigeria here, governance is done in a way that no matter who is sitting as the head of the government, like the governor, deputy governor, as it were, they hardly take any decision without passing through several advisors, senior personal assistants, and all other advisors, so to say, commissioners and all that. If you have all these people, you are not, there is nothing that is going to distract you by way of being punished for committing a crime or for violating somebody's right or doing something that is wrong. I don't see anything that would distract somebody there. Because all what they do in the form of governance is to sit down and get pieces of advice from other people and act on them. And so I do not see anything that is making them making governance difficult for them. If you are taken to court for violating somebody or for committing crimes, especially in criminal offenses, they are completely immune. And that is why when the moment they want to leave office, they will now look for a way to sneak out of Nigeria and escape from being arrested. That is why EFCC these days, they just lay
Let's see.
for them so that once they are out of office, they are grabbed. Because the immunity clause does not allow them. But I want to see a situation that if the immunity clause should be removed completely from the head, from the presidency. Why do you allow the president to enjoy the immunity clause? It shouldn't be there. It should be from the president, vice, deputy governor, and deputy governor. All of them should not enjoy this immunity clause. It is unnecessary in our own system of governance. It is unnecessary in Nigeria. And that is why they can commit crime with impunity, knowing that nobody is going after them. I think the moment that is removed and they are prosecuted for committing crimes, they will sit up and know that it is not right to be murdering people, to be killing people, and to be... Do you know that the president can be answerable for the death of people who died in the process of either protest or any other thing emanating from his own policy that has made those people to die? The president can be prosecuted for that. And if found liable, he will be sent to jail. But in Nigeria, there's nothing like that. You cannot, in fact, the president is seen as an a monarch. That is the right word. He's seen as a monarch. Nobody can get near him. That is why if somebody, even if you are elected as a governor or a deputy governor, you can just say you are removed. And Nigerians would applaud and then clap hand for him.
Yeah, then we know that this topic has been very controversial because some have argued that it is necessary to retain the immunity clause in our constitution because if it's removed, the governors, the presidents will have floodgate of litigation that they may not have enough time to attend to the issues of governance because civil litigations, criminal litigations will be there all over the place. And those that have been canvassing, crusading, and arguing that this should be retained is that within the period of their tenure of office, that they should be immune from any form of litigation or prosecution, whether civil or criminal. But as soon as they leave office, you can sue them, and then that in the course of computing the period for the crime or action in question, that the period they stayed in office will not be reckoned with. Now, that is the argument on one side. Then the argument on the other side, which you appear to be in support of, is that it appears that the immunity has given them license to commit atrocities, fraud, and all that. Now, from these two positions, which do you think is the best for Nigeria?
Well, let me first of all support very vehemently the argument of my good brother. I personally do not believe in this country that those who are in position of fiduciary relationship with the people, those to whom we have been trusted our life, those to whom are supposed to be in charge of the nation for and on the benefit of Nigerians, they should commit crime and get away with it. It is wrong, it is not fair, it is unjust in any society. And don't forget that the process of governance is a position, or the position of governance is a position of responsibility entrusted to somebody. So by virtue of being a governor or a president of a nation, you are holding a very, very sacred office. And such people should not be found to be committing crimes. Unfortunately, we have leaders who are deficit in credibility in this country. People who have so many cases in court for fraud, for allegations, or for things that are unlawful, criminal activities. And then they get into government and they get worse. And you protect them by immunity. Why should we retain that immunity? I don't think the provision on immunity in Nigerian constitution or in our laws is beneficial to good governance in this country. In fact, it is an instrument of bad governance. Yes. It is the reason why there is lawlessness, there is impunity in government, there is lack of accountability, lack of transparency, and all the A's, corruptions. That is because of immunity that we are having this perpetration of these criminal activities. And the moment they are removed, then you find that those who hold public office will be careful. Because number one, they know they can be investigated for any offense that they commit in the course of their official duties. They know they can be responsible for the crimes that they commit. We have had situations where people who are notoriously criminals are gotten into positions, president, governors of state, people who are stealing the wealth of the country. And at the end, nothing is done. And they have even extended the length, the duration of that impunity now. So even after their government, you now find that even after government, whereas the position of Section 308 is only those things that they do in the course of their duty, during the sphere of their official assignment. But you find that even after they leave office, they are still not held responsible because they believe that as at the time they did it, they had immunity, which was not the proper interpretation of Section 308. So, and I think when it is done away with completely, then those in government will be more careful about running the affairs of the state.
Now, the Supreme Court in the case of Fawemi and the IP held that those in governance on positions of authority like president, the governors, and the deputies or vice as case could be investigated during their tenure of office. But then the issue of prosecution cannot be carried out. Do you think that decision has not been exploited by our law enforcement agencies, particularly in the issue of investigation of crimes committed by those in positions of authority, to nip it in the bud? What is your position?
You see, I don't think it has actually been fully exploited. You see, several times when somebody is in government, is a position or is immune, any of those officers that are immune, at the time they commit this crime, the agencies, the investigative agencies that are supposed to go after them would not. They would just relax. You see, you need a petition to a particular anti-corruption or agency to be able to kickstart election.
Yes.
And so, if they receive these petitions, they simply leave it there until probably the time that the person wants to leave the office. They quickly run around to do some shabby investigation, and at the end of the day, they say that we are going to wait for him. By the time the man is even out of government, we have seen the shenanigans.
Exactly.
We have seen plays out now.
Yes.
They will just invite him to this, and they will go there and sit down and drink tea, and then get back to their place, and nothing is said about it again. If it is done timeously, investigation is carried out timeously, the person is prosecuted, we will not get to the point that we are now. The moment you are sitting down there, you know that if you commit any crime, so it will be investigated. We know that you can use money to try to suppress it, but there are some people that you cannot buy. Excuse me. And at the end of the day, you will be convicted for whatever offense that you have committed. People will sit up, as my colleague has said. People will definitely sit up. They will not be doing what they are doing now.
In other words, you're saying that if those in positions of authority, especially the governors and others, have looted some funds, and instead of waiting till the end of their tenure, by which time the funds may have been sent outside the shores of this country, stashed in banks abroad, that is better to deal with the situation timeously by removing the immunity clause. Is that what you're saying?
Yes, exactly.
You will find that even when they are in office,
Yes.
when they are in office,
Yes.
it's the best time to investigate them.
Yes.
Because you see, the documents are still there. They cannot toy with the documents when they are in office because it's an ongoing government. All right, but the moment they leave office, before they leave office, they make sure that they deal with all the documents, remove all the evidence.
Yes. Apart from removing evidence, documentary or otherwise, what do you have to say concerning the issue of governors looking for their stooges to replace them to avoid being investigated or subjected to any form of inquiry when they leave office?
You see, if this immunity clause is removed,
Yes.
all that will no longer play out. Because there is no need to look for somebody who will come and cover you up.
Yes.
Once you are in governance, you can be investigated. Anything can be done to bring out all the... We know those people that are working under them, these governors and they know
What is going on?
what is going on. They are the ones that will get this information out and they are investigated. You understand? The moment you sit on it and wait until they will look for somebody who will come and cover it and make sure that nobody is able to remove it and investigate the person. And that is what has been going on in this country. So I am opposed to the retention of this immunity clause. But unfortunately, my brother,
Yes.
I can't see this going through. With the crop of politicians, I didn't even expect it to surface at all because I know the crop of politicians that we have now, they will rather say that this immunity should remain so that this kind of impunity, corruption, criminal act will continue. But God is on our side. One of these things will go.
And I think why it has sailed through and why it is being projected is because it's an agenda. I don't, for instance, see why the president also should retain his own immunity. If the immunity of the deputy governors, the vice president is going to go, then that of the president must also go. This thing will only sail through if the president is himself. He is the one behind this bill. That's the only way to sail through. Knowing the National Assembly that we have now, that whatever the president wants, that's what they will do. Maybe that's why the president himself is not included in the list, in the bills of those whose immunity is to be removed. So I think the proper thing is the immunity of all officers should be done whether the president, whether the vice president, the governor, or the deputy governor. So to make them more responsible in governance and for us to have good governance.
Now, let us look at the other side of the coin. The other two arms of government have relative immunities. The legislatures, especially the National Assembly, and those are the lower, rung of it. They have their own immunities. Those, the legislators, in the course of their proceedings,
Yes.
whatever they do, they are immune. They are immune. They cannot be subject to litigation on account of what they say in the House, the motion, the resolutions, and all that. Now, if that of the executive is removed, do you think that of the legislature should equally be removed or be retained? What do you have to say, Pastor Deji?
Well, first of all, I want to say that borders on the aspect of freedom of expression. Because anything they say in the House is officially protected.
Yes.
And that is the essence, to make sure that whatever discussion they have in the House, that can be retained. It's not an immunity from prosecution. It's not an immunity from civil tort. If they commit any civil action, they are not immune to that extent.
Or even
criminal action, they are not immune to that extent. That's where it differs from that of the governor and the president. Their own immunity is just in relation to what they say. And I think they are entitled to what they say. Because it's freedom of speech, freedom of expression. And being in the House is also to be able to promote certain bills and give justification for the bills that you are proposing. So, to that extent, parliamentary immunity and privileges is okay. What is not okay is the executive immunity, which allows for recklessness in governance.
And
That's
also,
my view.
And also note that even those in the parliament, they are not immune from prosecution in respect of crime and tort.
Yes.
Outside, what they do in the chambers is
what?
They are immune.
Yeah.
But the moment they leave the chambers,
Yes.
they are not immune. Unlike these, the president, the deputy, and the vice president, and the governor, they are immune in total. Holistically, whatever they do, you cannot hold them accountable or responsible. That is what we are saying. This other one is just within the chambers of the assembly.
Yeah.
And what they get out, it's just like you cannot sue a judge in the performance of his duty, because that will be in the performance. You know what? There has various interpretations. The performance of his duty.
Yes.
But that does not mean that if judge commits crime outside, it will be picked up. The law will take its course. So that is the same thing with the assembly people.
Now, let us look at what you just mentioned, the judicial aspect of it. The judiciary equally has immunity. But curiously, in Nigeria, it is usually the judges of the state high courts that have immunity that are encapsulated in the laws of the various states. At the Court of Appeal and the Supreme Court, surprisingly, there appear to be no law that grants immunity to them. Could that be an oversight? Mona, what do you think?
I think that we don't need to really have a particular law that grants immunity to the Court of
Justice of Supreme Court and Court of Appeal?
Yes, because once we have that as from the judiciary and the High Court, it covers every other judicial officer that is sitting there. So the justices, I can't see them being sued for the judgment they have given or whatever they do in the court.
But what is good for the goose is equally good for the gander. If the Constitution made provision for immunity for executives and of course the legislature, don't you think it's necessary that gap be filled to cover justices of Supreme Court and Court of Appeal?
The law already covers them, just as he has said. The law says judicial officers.
Yes.
And judicial officers are judges of the High Court, Court of Appeal, and the Supreme Court. They are all judicial officers under our Constitution.
Yes.
So to that extent, the immunity covers all our judicial officers.
But it is not clearly stated in the Constitution, but that of the executive and the legislature are there.
But by convention, or even also by convention, the judges are sacrosanct. The judges are sacrosanct.
Judicial authorities are also there. To
back agree that
sue a judge.
Yes, but it's a yawning gap in the Constitution.
Well, the only point I will
the yawning gap that needs to be
filled. The only point I will agree with you is because of the brigandry of the current brigandry of this new set of president that we're having in Nigeria. We all saw what happened during the Buhari regime.
When the residence of
the
Justice Supreme Court was invaded.
Yes, invaded by police and military men in the middle of the night, and all of that, destruction of judges' properties, and cutting away of their documents and files and all of that. So to that extent,
what do you say to that?
To that extent, there may be need for a statute that will specially protect them from this executive recklessness. Yes. Of course, we know that once a country is going towards dictatorship, the way we are moving now, because Nigeria is gradually moving into dictatorship, only the judiciary is the only solace of the common man in any such dispensation. And of course, you find that the executive will always, go after the judges. We saw it during Buhari's government, and against Onoge, the way they went after Onoge, and some other judges like that. Under the guise of corruption, investigation of corruption charges, and all that, which at the end of the day came to nothing because there was nothing they found. So maybe there is a need for special protection, but that would be a special protection, not for the purpose of their judicial function. All right, so that their rights are not violated, so that you can make their right inviolable by executive lawlessness or recklessness. And of course, if you look at that, everybody needs it in this country. Every citizen will now need such a law to prevent government from violating their rights.
No, but we're talking about immunity.
Fundamental rights.
Fundamental rights here. Yes, it's there already. And if we look at it, you say that Nigeria is moving towards dictatorship.
Obviously, yes.
And that it's judiciary that usually halts such moves.
Yes.
And then what do you think? In yesteryears, we had instances where the court have had courage to declare illegal, unconstitutional, some actions of government, both federal and state. But in recent times, we see less of such, declaratory judgment, declaring the government actions illegal, null and void. Could it be that the present government, the governments at this time are doing the right thing, or that the courage of the judges to come out and like Justice Jinadu say whatever it needs to be said, declare whatever needs to be declared? What is your opinion?
Yes. Okay. Thank you very much. I still remember Honorable Justice Akinsanya of those days, late now, who declared the interim national government illegal.
Yes.
In the military regime.
Yes.
Nothing happened.
Yes.
The heavens did not fall.
Yes.
We need such courageous judges in Nigeria.
Yes.
I cannot imagine what we are having now. That certain things will be taken to the government, to the court, and then it will pass through the hierarchy to the Supreme Court. And the Supreme Court will make pronouncement and give judgment in a way that even a layman on the street will sigh and say, there's no justice in this matter. The moment you give judgment, and somebody who does not even know anything about law, based on legal technicalities, and somebody who does not even know anything about law, shakes his head and says, this is not a good judgment at all. You know that you are deviating into the abyss. And that is why I think my colleague said that the government is heading towards dictatorship. Because if you don't have a courageous judiciary that would declare a particular government action illegal, there's no way the government will not do what he likes. Because he knows that once he gets into the court will support whatever action he has taken, and that will be it. Without mixing words, I can authoritatively tell you that this judiciary is not courageous enough to do the bidding. It's not because the government is doing the right thing. No, we all see and know what the government does that is not right. But the court will now cap it and say that whatever that the government is right in that direction, and that is why I keep saying, if NBA has declared that the current state of emergency in Rivers State is illegal.
Yes.
If they take this matter to court, we might have a courageous judge in the High Court who will declare it illegal, even up to the Court of Appeal, what of the Supreme Court.
But you are aware that a judge in Rivers State gave an order restraining the sole administrator for taking over the administration of Rivers State.
I heard that there was nothing like that. Somebody said
Was it
that there was no restraining order whatsoever.
Okay,
well, of course, you can see the way the attitude of the executive, because of the lack of courage of our judiciary. They will tell you when they commit offense, they say
go to court.
They tell you go to court.
Yes.
Because they know that the courts do not have the courage.
It's going to give
and let me say this. It appears as if our judges, and I'm saying this to our judges, that they are not helping this country.
Oh.
Our judges are not helping. Why do I say that? Now, it appears as if their jurisprudence, the jurisprudence behind their judgment, is that of regime protection. I think I've said this before here. If you look at most of the judgments of the Supreme Court, and the judgment of some of the judgment of the Court of Appeal of political issues, you find that it's as if most of those judgments are for political expediency, just to assist the government to carry out their actions, whether it is lawful or unlawful. And most of those judgments are to protect the face of the government. It appears as if our judiciary is now out to assist the regime to carry out their function, the executive to carry out their activities, which should not be the function of the court, because the judiciary is supposed to be the arbiter between the legislature and the judiciary, and between the people and the legislature, and the people and the executive. So where they now see their function as that of regime protection, then we are already in a tyrannical government.
Are you suggesting directly or indirectly that the principle of checks and balances does not operate in Nigeria?
Look at the decision on Section 109, for instance. Now, the Supreme Court decision, that decision they gave has rendered Section 109 completely useless. Odious. That section is odious.
Yes.
That when you leave your political party, the moment the Constitution did not say how you live, or whether
that you must be registered in the other
party, or that they must accept you there. Once you make a declaration, you are no longer in this party. The Constitution says you have lost your seat.
Yes.
But we are now having a situation where the Supreme Court is validating the rights of people who had left a particular political party to another political party by their own declaration and action, by oath, by making oaths.
And the one that surprised me was this oath. The Supreme Court said that it's not in respect of swearing to an affidavit and saying that you have left a particular political party. You have to be registered in another political party.
It doesn't make
sense. But that's not part of the provision of the Constitution.
You are reading into the Constitution what the Constitution does put there. And the Supreme Court has no right to interpret the Constitution by bringing extraneous matter
something that is very straightforward.
Now, with all these things, what do you think is the solution to the predicament the nation appears to be going through, having suffered to ensure that there's independence in the judiciary? With what is going on, what do you think is the way forward?
The way forward is for us to have good separation of powers. Let each of the arms of government know that they cannot move into the other arm and subject that arm to their own benefits, whims and caprices. That is the only solution. Once the National Assembly knows that it is a National Assembly, not part of the executive, then it will be able to know that once a particular law comes in, it will be for the interest of Nigerians, not for the interest of the occupier of Asoro. The moment the governors know that what they are supposed to do is to ensure that they govern very well, the House of Assembly is not part of the appendages, so that they will instigate the members to remove a speaker and close down the place, and sometimes even burn down the House of Assembly. The moment you are able to know that you have no right to move into this arena. And that is why this immunity thing has to be removed, because once it is established that the governor is the one behind this burning down of the House of Assembly, it should be prosecuted. And
All right,
all these things will stop.
we'll go on a very short break. And when we come back, we'll take a look at our second topic. Stay tuned. We'll be right back.